number 124, Global Reinsurance versus Century Indemnity. Counsel?
Good afternoon, Your Honors. John Hacker for Century. I'd like to reserve 2 minutes, if I may.
2 minutes, sir?
Thank you.
You may.
Your Honors, Century issued policies to Caterpillar that paid defense costs in addition to their indemnity limits. The reinsurance Century obtained on those policies does the same. The plain language of the certificate says so without ambiguity, and you can find the relevant provision at page A89 of the appendix for Certificate X.
Counsel, the Second Circuit's asked us a relatively narrow question in this case, right? It's, does excess in our excess case create this presumption or this rule? And do we need to overrule excess in order to get out of a presumption or a rule here?
We don't think so.
Why not?
We don't think excess on its face establishes the kind of presumption that would be at odds with and contrary to the presumption of concurrence that the plain language of the certificate here and in other certificates creates. That the focus.
What's the difference between the facts in excess and the facts here that would make us, it seems like create a different rule or a different application at least?
The key difference is the fundamental facts. Excess presented a different question which was about an insurer's own coverage costs that it incurred in litigating coverage with the insured, and the question was whether or not those insurers' own coverage costs were within the limit of the reinsurance certificate. That has nothing. The answer to that question, which the court said was that you couldn't rely on the follow a settlements provision to override what the parties stipulated to be the limit. That has nothing to do with whether or not, when you're talking about the underlying policy, which does cover defense costs, does provide for the insurer to pay those defense costs, and the certificate says and instructs the parties that the certificate is going to provide this, follow the form of the underlying policy. If the underlying policy pays defense costs outside indemnity limits, then the following form provision instructs you to do that. Here's what the provision says. It's
Can I just, before you get into this provision, I just have a question about the certificates, which will help me. So in the appendix, you have all the certificates, but were they before the appellate division? Or was just Certificate X or just Certificate X and some other certificates? Because there are some of them that have these check the boxes, which Certificate X doesn't have, and which may or may not make any difference.
I don't think it does make a difference. They were all before the District Court and the Second Circuit.
They were.
And the parties agree that for all intents and purposes and all material specs, they work the same, even though there are various differences amongst the language. And let me focus, because I do think it's important. Excess, the other thing excess does is instruct the court to look at specific contracts. Here's what this one says. The liability of the reinsurer specified in item 4 shall follow that of the company, and, except as otherwise specifically provided herein, shall be subject in all respects to all terms and conditions of the company's policy. So under that following form provision, the reinsurance simply does whatever the Century policy does.
Would your answer be the same, putting excess aside, under the two circuit cases, Unigard and, would your answer be the same? Do those, if we apply those cases, I mean, they're not our rules, they're circuit cases, obviously, but if we were to apply those cases, what would the outcome be here?
It would definitely be the same under Belafont, which reached, is sort of similar to excess. It didn't have to, it reached its result in dealing with coverage that wasn't provided for in the underlying policy. And the question there as an excess was whether a follow the settlements clause allowed you to override the limit. Unigard, yes, extended it to a follow the form provision, but I'll emphasize that in Unigard, the language there didn't have the word specifically. Maybe a technical distinction, but specifically has to mean something. But we don't think Unigard was correctly decided, and Belafont can be defended on a different ground.
And does that create a problem for you with excess? Because it seems like in our decision in excess, we're citing favorably Unigard.
The answer is no, because in the passage in excess in which the court cited Belafont and Unigard, it's describing both of them as follow the settlements cases, not dealing at all with the question in this case, which is when you have a follow the form provision that requires you.
So then you're not really advocating that we adopt Judge Reed's dissent in excess?
Not necessarily. So far as excess is concerned, the only question is whether it creates a presumption that is effectively the opposite of the language in this certificate and the tradition of reinsurance law? And the answer to that clearly is no, because the question was never presented. There was no issue in excess as to whether or not, when you have a provision that says, do whatever the underlying policy does, unless there's specific language that tells you not to. That's the question here. And excess just didn't address that.
So is your position the presumption can be overcome, or the presumption never applies?
It absolutely can be rebutted, that as this provision says, if there's language that specifically provides that the certificate is going to do something different from the underlying policy, you have to find specific language. And everybody essentially agrees with that. Now, Global tries to resist the idea of the presumption, but they can't resist the plain language of that provision. So what they do is say, we've got language. There is language in the certificate that specifically provides that the defense costs are inside the limits. They point to only two provisions. One is the preamble, which says, in very general terms, the reinsurance is, quote, subject to the terms, conditions, that's the following form provision, that's the first thing it refers to, and amount of liability set forth herein, and this is page A88. That preamble on its face doesn't address whether the, quote, amount of liability includes defense expenses or treats them outside the indemnity limits. It just doesn't say anything about that question. And if you take it seriously and think that amount of liability really does mean something in that particular passage, then it's contradicted by the following form provision itself, which says that item 4 liability is, quote, subject to the terms and conditions of the company policy. So at best, what you've got is a contradiction there, which has to create at least an ambiguity, which means that Global's position cannot stand. We think it's easily reconciled because neither provision is telling you what the amount of liability refers to. That is established by the plain language of item 4 read in context on the declarations page. What that says, first of all, item 2, which you see at A88, item 2 sets forth the, quote, policy limits of the Caterpillar policy and refers to $1 million, which is, everybody has to agree, is indemnity loss only. The $1 million policy limit, that's the word, limit, is indemnity loss only. Then item 3, the company retention, Century's retention. The primary policy is $500,000 of the liability in item 2. So item 3 is referring only to indemnity loss, not including defense expenses. Then we get to item 4.
The indemnity loss argument is predicated upon extrinsic evidence that you would say that the custom and practice of the industry is this is the way it's read, correct?
Not quite.
Okay.
I haven't referred to any extrinsic evidence in describing what it is that
No, but for you to be ultimately successful, don't you have to reach, doesn't this court have to really guide you to that conclusion? Don't you have to say that we analyze this under the ordinary rules of contract, and if we do that, we've created an ambiguity here, and therefore we're allowed to get the extrinsic evidence in, custom and practice. This is what happens in the insurance industry.
We're happy to be thrown in the briar patch of ambiguity because there's only going to be one result when you actually
You
get
see,
into
the
custom
policy
usage.
implications could be kind of frightening in the insurance industry if we start characterizing each one of these contracts as ambiguous.
Well, I don't quite agree because when there's been ambiguity, for example, in the Munich Re case, they abandoned the defense. When anybody gets into custom and usage, one side prevails. But I want to be very clear. There is an ambiguity here. You don't need extrinsic evidence to understand what items 2, 3, and 4 are doing when read together. Item 2 refers to $1 million in indemnity loss. That's just on its face. It does, and nobody disagrees. Item 3, $500,000 of that being retained, indemnity loss. Nobody disagrees. Then we get to item 4. It says the other $500,000, the excess policy, what it says is that
250 of that 1 million is covered by the
reinsurance acceptance is
reinsurer.
$250,000 of the $500,000. Part of the $500,000. That $500,000 is indemnity loss. So the $250,000 is part of the same $500,000, which is indemnity loss. The $250,000 does not and cannot include defense expenses. It would be like saying if you have a gallon of milk and they're going to take part of the gallon of milk, it's got to be milk. What their argument is we're taking half the gallon, but what we're taking is milk and orange juice. It has to be the same thing, and the $500,000 is unambiguously indemnity loss only. It doesn't include defense expenses. That's provided for elsewhere.
Let me ask you a quick hypothetical, if I may.
Yes, you may.
So if the insurer litigates the underlying dispute and wins, and therefore $0 have been paid out of the $1 million, all right, how do you figure out the proportion of those expenses that are going to be covered by the reinsurer?
So that's a litigated question in other cases that's not presented here. Nobody's disputing that issue. But it's, when the insurer incurs cost to prevent indemnification liability, so the reinsurer ends up having no liability whatsoever, the insurers argue that you should bear part of that. Most reinsurance certificates include a way of calculating that. Certificate X does not. That's true. It provides a different formula that, as Your Honor points out, doesn't exactly work in the zero liability situation. But the insurance position in that situation is you basically apply the same proportion as between the amount of liability assumed of indemnity loss. So in this case, it would be 50%. Each of the reinsurers would bear 50% of the coverage cost. But that's a completely separate question that isn't addressed here.
Thank you, Mr. Hecker.
Thank you, Your Honors.
Counsel?
Thank you, Your Honors. David Frederick for Global Re. Judge Feinman, if I could start with your question. The answer proves that there is no concurrency over expenses. And that's because if there's no loss, there are no expenses that are paid by the reinsurer, and that is set forth clearly in the terminology on page A89. There's a case on that point called Seneca, which we cite and quote in our case. And so if it is the case that the insured, the cedent, has to incur expenses in defending the loss, but if it wins, those costs and expenses are not then chargeable to the reinsurer, the entire theory of concurrency proposed by my friend goes away completely. And that is one of the reasons why you should answer the certified question, yes. There is a well-established, settled construction of these reinsurance certificates so that there's a cap on the loss and expenses that are chargeable to the reinsurers. Excess.
Okay, so,
Is that under excess?
I'm sorry.
Under excess?
Under excess.
So can
excess actually
can it be
considered.
distinguished as Mr. Hacker suggested?
It's not distinguishable because
Why?
although the way that the follow form and follow settlements were constructed, they were in that agreement. And this court, in fact, held that in excess that the same principle applies in property as it does in liability, which were the insurance policies that were issued in Unigard and Bellefonte. And I would point out that this court, 3 years before the excess decision, considered the applicability of Bellefonte under New York law and reaffirmed it. That's the Travelers decision. And in Travelers, what the court held is that for reinsurance certificates, you take these terms and you do not read them, these follow the fortunes, follow form clauses, to nullify other terms. That is exactly what Century is arguing here. They want you to nullify the amount of liability provision, which creates the cap for precisely the reason that this court recognized and the Second Circuit recognized in the trio of well-settled cases.
But let's go back a step. And I guess my concern is whether, and it's something that has been alluded to by two of my colleagues already, is whether excess is really decided properly in the first place. And it seems to me, based on a lot of the reading that you provided us, that certainly in arbitration decisions, nobody's following any of this, whether it's Bellefonte, whether it's excess. And if that's the case, did we maybe make a wrong turn?
No, you did not make a wrong turn, and I would posit that there's no evidence other than the suggestion that one arbitrator in one case with one unspecified contract language assessed the expenses and said that
would be
Bellefonte didn't
Gerling,
apply. That is a made-up fact, Judge Feinman, if I could use that term in strong language. The cases, in fact, have followed Bellefonte. This court has followed Bellefonte. This is the third time the Bellefonte rule has been before you. And the first two times, you ruled that that was an appropriate way to view reinsurance caps. So, Judge Revere, to your question, absolutely, excess has to, sorry, my apologies. Yes, you would have to overrule excess in order to rule in their favor.
Right, but isn't the circuit itself suggesting in their decision, sending us this question, that they themselves are questioning Bellefonte and Unigard?
They are questioning it, but I would posit that the reason why they're doing it is that they would like an end to the challenges that are being brought by the cedents to this rule. And the reason why the cedents are challenging this rule is that there has been a change in economic circumstances for this entire market for long tail. So the reason that you're being asked to reconsider this question is because the cedents want to get a windfall. They've bought these lost portfolio transfers on the basis of prices that factored in the Bellefonte rule. If you overturn the Bellefonte rule, they get a windfall.
So does the fact that these are long-tail contracts make stare decisis more important?
Yes, because the contract considerations for stare decisis are at their acme. Parties can contract around the Bellefonte rule for future contracts if they want to. The parties that are all applicable here and the amici all made economic decisions on the basis of the Bellefonte rule.
Well, doesn't that make it even more important then for some court to have the benefit of some evidence of what the understanding was at the time that these policies were entered into?
Well, the courts that have looked at this have relied on the New York law principle that one looks at the plain language of the contract in resolving it and not follow the California practice of allowing extrinsic evidence that would lead to the interpretation of these terms.
Well, you could make it a lot plainer, right? I mean, everybody seems to complain and have views on how the courts are interpreting. Why don't you just say what you mean in the contract?
Well, I think that as the modern practices are evolving, there are changes to these terms. But I would say that the courts that have looked at this from excess, which was before Judge Schindlin, before it came over to the state court system, she did not find there to be ambiguity. And she said that even to the extent that there is a little bit of ambiguity, it's for the court to resolve. So, Your
On
Honor,
a factual question, it seems to be some conflict in the record, although maybe I'm reading it wrong. One position seems to be, let's say you're taking 50% of the reinsurance, 50% of the risk, you get 50% of the original premium, or some variation of that based on costs. There's another part of the briefing that seems to suggest these premiums are renegotiated every year. What is it?
they were renegotiated. These particular premiums were renegotiated, and they were not 50% for the reasons that we've set out in our brief. In fact, this is another reason why these are not concurrent terms. The underlying policy was for a 3-year term. The insurance certificates, however, were only for 1 year. So if the asbestos problem had arisen in the first year, the reinsurers would have been free not to re-up in year 2 or year 3. And when they did re-up, the facts are very clear here, they did so on the basis of different premiums. And so you can't use the premium argument as a basis for implying a judge-made doctrine or spin on these provisions. In fact, in Unigard, the court made very clear
Is the renegotiated premium in some way tied to the risk percentage?
Well, it is tied to the perception that the reinsuring underwriters have of what the risks are, and that's why you have to separate reinsurance risk from the underlying policy risk.
That's a little bit confusing to me, but let's put it in simpler terms. You have $1 million policy and you're reinsuring $500,000 of that. Now you're renegotiating the rates here. Is your premium passed through to the reinsurer in some way based on the 50% risk assumption?
It is based on the risk that the reinsurance is going to be pierced. And so to that extent, it goes to which layer the reinsurance is going to be pierced. So if you take the first $500,000, there's a risk that that first $500,000 will be pierced. Then you take the next layer, the $250,000. What is the risk at that $250,000? And there are actuarial analyses that go into that, and so that is why this type of excess of loss, the treatise writers say, is non-proportional, because you have to look at what the reinsurance risk is that a particular layer is going to be pierced at a particular point in time.
So the last $250,000 in the hypothetical, if you split it, would be a lower premium than the first $200,000.
That's correct. And that's why what this court and what the Second Circuit recognized in the trio of cases is that the reinsurer has an interest in capping its exposure. That's why these terms, amount of liability, limit of liability, are put in the reinsurance clause preamble because they want to make clear to the world in the very first opening lines of this certificate, that's the limit.
Sort of, on the other hand, the ceding insurer has an interest in sharing their insurance costs. So that's what they're looking to have in their agreement, which is why it's maybe not so clear.
No, but Judge Stein, here, the sharing goes to what the indemnity loss is, but the problem
Not for
here...
them, it doesn't. The expenses come right out of their pocket.
The expenses, and if you look at the language on page A177 of the appendix, are explicitly, quote, in addition to, they are supplementary payments. So they are not, they are separate and apart from the indemnity loss numbers. This is a separately contracted for provision. Had the reinsurer wanted to have that in parallel or concurrency, it would have written it that way, and it did not. Instead, what it did was it wrote, except as specifically provided herein. And that's why the Second Circuit in Bellefonte and Unigard and this court in excess said, we're going to honor the reinsurer's desire to keep a cap or limit on their policy exposure precisely because they don't have an ability to control those underlying costs. And this case is a perfect example of that. 90% of what Century is seeking to pass on to Global is costs and expenses from litigation where they conducted malfeasance, according to the Illinois courts, and did not defend Caterpillar. And so it would be odd to suppose that you would read a contract overriding a limit of liability so that the reinsurer now is tagged with paying for their malfeasance.
Thank you, Mr. Frederick. Mr. Hacker?
So the made-up fact here is that the net premiums were not proportional. They were exactly symmetrical. A150 is the only evidence in the case, and it's undisputed. It was never contested, not once by Global, anywhere in the federal litigation. They're completely net proportional. If they had raised an issue, we would have shown exactly how it actually plays out. That first policy was changed after 4 months to an annual policy. There's much more story there. But the bottom line fact is the net premiums were always follow the risk, which is just as it should be. Mr. Frederick, I think, gives away the case when he says correctly that expenses are in addition there too. They're separate from the indemnity losses. That's correct. Items 2, 3, and 4 are talking about the amount of indemnity loss that's being shared. Defense expenses are in addition there too. How do you do that? How do you treat that with a certificate? The answer is the following form provision says you just do whatever the underlying policy does. Because why wouldn't you? Especially when the net premium is following the amount of risk that you assume.
I'm sorry to harp on the net premium, but doesn't that make sense that if, let's say with a hypothetical $1 million policy, they retain 500 and it's 250. Wouldn't the premium for the last 250 be less than the first 250 because of the likelihood you're going to reach that amount in a settlement or a verdict?
The separate premiums might be, but that has nothing to do with the defense cost obligation because within each layer, it's always the same. Look at Certificate X. It's an excess policy. It's not actually one policy. It's an excess policy that is 100% reinsured. They split the premium equally between the two reinsurers. There's nothing left. We didn't have anything left other than the net amount, the ceding commission, which compensates for other costs. We gave away the entire premium on the excess policy, and their theory is, unbelievably, we kept all the liability for defense costs exceeding the amount of indemnity loss. That's a separate provision, as Mr. Frederick provides.
So, again, forgive me the basic question. So you're saying the premium for the excess policy, let's say we split it 250, that entire premium, whatever way you cut it up, goes to those two reinsurers minus whatever costs?
Yes, all of it. 100% of it, and yet we are being stuck with all of the defense cost liability in excess of the indemnity loss, which is a separate liability.
Yeah. On the defense costs, the expense costs, are you arguing that they should be prorated, that they should be broken up in the same way that your liability costs are, or are you arguing that they assume all defense costs over that amount?
The in addition thereto clause, yes, under this policy, since we gave away, under the excess policy, yes, the defense costs are borne by the reinsurers. That wouldn't always be true in different kinds of excessive loss policies.
And that amount in this case would be somewhere 90% of $90 million, is that right?
Whatever the amount is, it's shared equally with all of the reinsurers. That was the deal that we took. They took all of the premium. We didn't keep any premium to cover any defense costs, zero. So we wouldn't accept any defense cost liability. It wouldn't make sense to do that.
Thank you,
Thank
counsel.
you.